What will Garland do? I'm Michael Smerconish in Philadelphia. Attorney General Merrick Garland may eventually make a singular decision that determines the outcome of the 2024 election, whether the DOJ will continue to push for Donald Trump to be tried before Election Day in the federal case premised on alleged election interference. For months, here, I've delivered commentaries focused on the timing of this particular prosecution because I think it's most perilous to Trump. And I've often done so with the assistance of Ellie Honig, who'll join me again in a moment. Here's the issue. On Wednesday, SCOTUS granted cert and announced that the High Court will hear Donald Trump's immunity defense. I don't think the ultimate outcome is in dispute. I think Trump loses that claim. In my opinion, it's unlikely, it's illogical that the court will provide blanket immunity from criminal prosecution to an American president. More important is the process, the timing of the court's decision. Garland told CNN's Evan Perez in January that the cases were brought last year and that the timing is now in the hands of the judicial system. We know that the Supreme Court's oral arguments on Trump's immunity claim are scheduled for the week of April 22nd. We don't know for sure, but it suggests the decision is probably then going to come in June. And Judge Tanya Chutkan has said that she will provide the parties with 3 more months to prepare for trial. That means we're talking end of summer, coinciding with Labor Day, the traditional start of the final sprint toward Election Day. The first debate is scheduled for September 16 at Texas State University, and voting begins as early as September 20 in 3 states, Minnesota, Virginia, and South Dakota. But the DOJ has a standing policy of not taking certain actions close in time to an election. 5 recent attorneys general have all signed the same memo affirming the importance of keeping politics out of investigations and criminal charges. Republican Michael Mukasey in 2008, Democrats Eric Holder in 2012, Loretta Lynch in 2016, Republican Bill Barr in 2020, and Democrat Merrick Garland in 2022. They've all used the same language, including this paragraph, quote, "Simply put, politics must play no role in the decisions of the federal investigators or prosecutors regarding any investigations or criminal charges." I'm going to stress this part. Law enforcement officers and prosecutors may never select the timing of investigative steps or criminal charges for the purpose of affecting any election or for the purpose of giving an advantage or disadvantage to any candidate or political party. The U.S. Attorney's Manual has similar language, and when you think about it, it all makes sense. If law enforcement officers and prosecutors may never select the timing of investigative steps or criminal charges for the purpose of affecting any election, then perhaps the logic would preclude them from influencing the timing of a trial for the purpose of affecting an election. In the Mar-a-Lago document case, Special Prosecutor Jack Smith asked Florida Judge Aileen Cannon for a July 8 trial date. Trump's lawyers are asking for it not to be held until after the election. They're arguing that otherwise it'll be election interference. Yesterday, Friday, Judge Cannon held a 4-hour hearing on that case, but did not make any trial scheduling moves. She did, however, raise the issue of the so-called 60-day rule. Special Counsel Prosecutor Jay Bratt said the DOJ policy does not apply to cases that have already been charged, and that the department had reviewed the policy to ensure they were in compliance. The trial date in the January 6 case will be set by Judge Chutkan, not the DOJ. But rest assured, Trump will continue with his delay tactics, hoping that he will win the election and either have DOJ stop the prosecution or self-pardon. The way the DOJ influences the trial date will be in either agreeing or opposing Trump's delay tactics. So here's the question for Merrick Garland. Does the policy which avoids an appearance of politics in investigative steps or criminal charges extend to actually trying a case? Arguably, the investigation is over. The criminal charges, they've already been filed. So prosecuting Trump in the lead up to the presidential election would not technically run afoul of those DOJ docs, like Jay Bratt said yesterday in the Mar-a-Lago case. Nevertheless, does Merrick Garland want the perception of putting a former president on trial at a time when he will be his party's nominee? If Garland is hesitant to do so, then where's the line for when it becomes inappropriate to try Trump? Is it 60 days before an election? Is it 90 days before an election? There's no precedent for this situation. No rule book governs this particular scenario. Truly, we are in uncharted waters. And Merrick Garland is holding a lot of the cards. It all leads me to today's poll question today at Smerconish.com. Go and vote on this. Is it appropriate for DOJ to try Trump in the fall of 2024? Joining me now is Ellie Honig, CNN senior legal analyst, former federal prosecutor. Ellie, thanks so much for coming back. I think I made clear judges set trial dates, judges do, but to what extent can a prosecutor affect that decision?
Well, the prosecutor has a substantial say in this decision, Michael. In every case, not just this one, there's always this sort of push and pull going on where prosecutors are saying, Judge, we'd like to try this case soon, usually sooner, and typically defendants are seeking to push it back. Donald Trump did not invent the delay tactic, take my word for it. Ultimately, it is the judge's call, but you are absolutely, as a DOJ prosecutor, you are making a conscious, specific strategy call in when you ask a judge for the election, and judges do take that heavily into account.
Okay, 60 days, 90 days, where can I go and read it? Like, where is this standard, Ellie?
It is nowhere, Michael. So this is sort of an urban legend within DOJ. It comes from that two-page letter that you just showed in your introduction, which is sent by AGs of both parties over the last 2 decades or so. But that letter, what it says is that we at DOJ need to be careful and avoid taking publicly visible steps on a case that might affect the election too close to the election, but nowhere does it actually say the number 60. In fact, there's a little bit of variance. Where I was a prosecutor in New York, we were always taught it was 60 days, but you can get people from other districts federally who will say they were taught it was 90 days. But the spirit of the rule throughout is basically, we don't want to do things that will be visible to the public that might influence an election too close to an election.
You and I have spoken in the past of how, relative to Jack Smith's pleadings, the election is the Voldemort, that which is never spoken explicitly. Nevertheless, if he is pushing to get the case tried before the election, is he running afoul of the documents that I showed, the Attorney General memos that we've been referencing?
So Jack Smith's team was asked that exact question, as you discussed earlier in court yesterday, and they sort of threaded the needle and said, well, no, because we interpret that rule that we don't do things close to the election, that only applies to investigative steps. And they're right. It applies to, for example, you would never do a search warrant on a candidate 12 days before an election. You would never indict a candidate 14 days before an election. But if you look elsewhere, if you look at the actual justice manual, now this is essentially the internal Bible for DOJ. We all had them printed out on our desks. There's a provision in there that says prosecutors should never select the timing of any action. Let me say that again. Any action with the election in mind, with the timing of the election in mind. And it's hard for me to square that with Jack Smith making decisions, asking for trial dates, asking for everything to be mega expedited, because even though we won't say it, I don't think anyone would disagree that what's motivating him is the election date. So I do think that that violates DOJ's own internal manual.
So at a certain point in that hearing yesterday in Florida, I know this is probably confusing for people who are not in the weeds on it, but at a certain point in that hearing, the Trump lawyers, and of course they don't want the case tried before the election, but at a certain point they said, well, maybe August would be appropriate. And I wondered, Ellie, are they potentially using the Florida case to block the January 6th case? Because as between the two, and I'm curious to hear your thoughts, they'd probably rather he be tried for the Mar-a-Lago documents than the election interference in D.C.
That's exactly my read. There's a strategic play happening here that we just saw yesterday. So I believe that Donald Trump's team thinks that they would, if they had to choose, they would rather try the Florida case, the documents case, than the D.C. case. First of all, Trump's team is going to have a way more favorable jury pool in Florida than they will in D.C. if you just look at the popularity numbers, the voting numbers. And second of all, I think they've calculated that there will be more political damage done on the January 6th case. It's just more damaging conduct that's more problematic for Donald Trump. And so when they asked yesterday the judge in Florida for an August trial date. I don't think they really want an August trial, but I think what they're trying to do is block out August, September, October to make it impossible for the DC case, the January 6th case, to get moved then. And by the way, if a trial date is set for July or August in Florida, that's not set in stone. Judges set trial dates and then something else comes up and they move them back all the time. So I think there's a two-step here. I think they're saying, okay, Florida judge will accept the trial in August and then watch for them in June or July, Trump's team to go back and go, something happened, problem with the classified documents, now you need to move it past the election.
Quick final question. As between Merrick Garland and Jack Smith, who is calling the shot as to how aggressive to be in pursuing for a trial, even if it means in the fall?
Well, it should be Jack Smith's decision. If we look at the guidelines about that govern special counsel, it says that the special counsel is not subject to the day-to-day supervision of the Attorney General. Merrick Garland has made very clear, I'm not calling the shots here, but I do think it's also worth noting, Michael, if we have to apportion blame here within DOJ, let's remember, the reason we are under a time crunch is because DOJ had unilateral control of this case and when they charged it, and they did not charge it for 2 3/4 years. Most of that blame falls on Merrick Garland. Jack Smith actually indicted this case about 9 months after he took over. And so when they indicted this case, I don't know if people even remember this. This case was indicted in August of 2023, 7 months ago. And when they indicted in August 2023, DOJ left themselves and all of us with about 1 year to get this case tried. An enormously complex case. They should have known there would have been major constitutional issues like this. I wrote about it in my book before this case was even indicted. It was obvious they left themselves with not enough time. And the fact that we're in a time crunch now, I think mainly the blame here falls on DOJ, specifically Merrick Garland.
It's a great point. Ellie, thank you as always. Really appreciate it.